experience of the society, some problem which the representatives of the society in a democracy wish to solve. They devise their own, right or good or not so good, they devise design, they make a law. It happens. Same thing happened when this question came, when this became a very troublesome feature of making appointments without even informing the Chief Justice of India. The backlash was the second judge's case under which the collateral theory was propounded. In fact, Justice Verma, who was predominantly the author of the judgment, makes a one of the penultimate paragraphs. It says, the whole exercise is not undertaken in the spirit of winner takes all. It is an exercise but to be jointly undertaken by the legislature, the executive and the judiciary to identify the best person for the office. That was if you keep that in mind, all these questions, all this rhetoric will not come into. Now, as human experience shows, political philosophers say, power corrupts. All forms of corruption, including judicial power corrupts. Once the power came into the hands of the judiciary, there have been instances where very undesirable people have been elevated on very wholesome considerations. I don't want to go into the details, it will be very unpleasant to talk about names and people. There's quite a few of them happened, but I indicated in my dissenting judgment. Now, the point is, this is how the interpretative process goes on. In this process, if the dropping of the expression governor in this discretion, which occurred in the Government of India Act, which is not there today in the Constitution of India, must have some significance, some meaning. So it is a matter to be explored and interpreted. And under the system, interpretation of the Constitution and the laws is the job of the judiciary. That's how the interpretation started. I'll come to that question later. But broadly, I'm indicating the area. Now, the point is, we're talking about federalism. What are the factors which constitute a federal political entity? Different units, geographical units, getting together to constitute a larger body for achieving certain common good, like the defense of the people and all those things which are incidental to the nation. And when different people, different geographical units and inhabitants of those units get together voluntarily, necessarily they surrender a part of their sovereign authority. Olden days, the sovereignty was believed to reside in the monarch, one individual. Those days are gone. For the last few centuries, when the democratic politics have taken root in the world, people come to recognize that ultimately it is the people. It is the people who are sovereign. It is their power which either a monarch exercises or an elected prime minister or chief minister exercises, the power of the people. Now, but what is this? Was it a voluntary association in India? I have my own doubts. The entire freedom movement was essentially a movement against the rule of a foreigner. Beyond that, most of the common people never thought of anything beyond that. No. The people like Gandhiji or XYZ, Nehru, who was the leaders of the movement those days. They were educated in the Western system and they had a better understanding of all these things. But for a common man, what simply meant was rid of the white man. That was the only requirement which drove masses of this country. Once that's achieved, whatever, we have indications in the Constituent Assembly debates. The framers of the Constitution were a little worried whether this country, after losing the British government, throwing out the British government, would still survive as a cohesive body, because we have seen in our own lifetimes all kinds of divisive attitudes in this country. Because the country is such, there are innumerable divisions based on caste, community, language, region, religion, so on and so. Think of it. If there is none, we will invent some politics, political party. Anything can be a good ground for dividing people in this country. Well, that's human nature all over. Maybe it happens in different names in different countries, but in this country also it happens. Well, here I enter a caveat. I would rather be careful about what I am going to say. For a long time, including the last Winston Churchill and many people before him, the British Prime Ministers, British administration, very strongly believed that Indians are incapable of ruling themselves. And belief which they thought that they are more competent, more knowledgeable, they are more politically aware. Only they have a responsibility to rather uplift the expression was as well, the gentos. Maybe at the time of the formation of, I told you, without any malice or without anything, I have suspicion maybe that belief still lingered. When it comes to the states, the arrangement into the Constitution, the same arrangement which continued under the Government of India Act, the governor, see, if the governor is suppose under the scheme of the Constitution. First of all, why do we have governors is another question, whether it is required or not. You have heard the senior politicians in this country occasionally shouting, abolish the post of the governor. That's another story, I'm not on that. But as the Constitution exists today, there is a governor who is part of the legislature. A bill becomes a law only after receiving the assent of the President. Then I fail to understand the rationale behind investing that some kind of a loose discretion the governor would withhold. That expression withhold is still there in the Constitution. Now, that must be given some meaning. Withhold for what reason? If the governor perceives, let us say, that a particular bill is totally beyond the competence of the state legislature. It deals with a subject which is exclusively the subject assigned to the parliament. If the governor entertains such a doubt, there are ways of ascertaining the correctness. You can seek legal advice. There is an advocate general. His opinion. Or you can consult anybody else, any other lawyers out there. You can ask the attorney general. Some concrete ground on which the governor may entertain is possible. It's not necessary that every time whatever the majority decides is right in law or fact. The latest example for this whole idea of constitution and guarantees fundamental rights is this. All of us would have heard of Socrates and the story of Socrates. He was killed by the state by administering poison called hemlock. Why was he killed? It was believed that he was propagating wrong ideas, spoiling the youth. Therefore, he is a menace to the society, he must be killed. Wonderful, that's a different matter. The point is, who took the decision? It was not an individual, like Chalamesh or XYZ or something like that. The entire citizenry of Athens gathered, the city-state of Greece, entire citizenry gathered And they declared that this man is propagating bad ideas. And he was duly killed thereafter. Socrates was a great mind by the standards of his own times. Not that everything he said was gospel, there was modifications on everything, but it was a great mind, certainly. So therefore, merely because the majority decide he should be killed, it doesn't become a right. It may be the most democratic act because all the people participated, not an individual getting nominated by the president or the chief justice of India. The people of the something we have been hearing in the last 30 years, the Taliban type of trials. People gather there and decide it. Something like that happened in all Greece. It didn't start with Taliban, it started much before in Greece itself. So therefore, this majority opinions, majorities are transient. The political party which enjoys a tremendous popularity at a given point of time may at a certain point of time later lose that popularity. We have seen before our own eyes various political parties all over the country. So therefore, don't make it dependent purely on the temporary opinion of the masses. Sometimes masses are swayed away by emotions and politicians can comfortably, I'm sorry, I don't mean any personal offense, but we have, history has seen, all of us have read the Julius Caesar drama. You remember those fiery speeches of Brutus and Mark Antony? Within minutes, the opinion of the public changed. They could sway the views of the public. So, to protect people against such dangers, this whole constitutional system and the constitutional documents, this idea was invented, where certain fundamental values, which can't change the majority opinion of the day. The majority may change tomorrow, they may hold a different view. But even then, right and wrong can't depend purely absolute in the sense certain basic values can't depend whether the government should give 2 rupees a kg rice or free cell phones or not. Well, it may be a matter of choice. Whether I should have a fair trial. Suppose tomorrow somebody were to accuse me. Look here, Chalavashar gave a speech which is a criminal act. There must be some independent way of deciding whether there is anything criminal about my speech. Those are the higher levels of values which are contained in the Constitution. Now, if that is the system, this process of simply borrowing and copying from the Government of India Act, is not an indicator of the fact that the Constitution of India really wanted a federal political system as it occurs in America. It may be a different brand of federalism in this country, whether it's right or wrong, then finally it's for the people to decide later. Now, one more indicator. We have, I'm sorry, there must be some, I'm told there are some retired bureaucrats here. I don't mean anything personal against any one of them. Not that I'm afraid, but I'm just making my. We are still happily continuing with the old system of IS. If we are really federal, why should an officer recruited by the Government of India, who is subject to the disciplinary control of the Government of India, deal with the affairs of state? But in the federal society, in US, it doesn't happen. The officers appointed by the federal government deal with federal subjects like defense or let us say currency, XYZ. The federal structures only for the federal taxes. The taxing system is different. The state taxes are different in US and federal taxes are different. The officers are appointed by the Federation, the American Federation, deal only with those subjects. Here that distinction is not there. An IS officer, a police IPS officer appointed by the government or commissioner created. They are ultimately under 309. They are employed by the President of India. technically. Why should we be happy with it for 70 years, let them continue? I am not on that. But to indicate that this is certainly not an indicator of federalism in the country. Two. Third indicator. In federal constitutional structures, the legislative powers are clearly demarcated. In America, the federal legislation has enumerated powers. A limited number of items are included in the enumeration. In India, we have three lists. One union list, one state list, one concurrent list. Whatever is the necessity, that's a different matter. I am not entering a full-fledged discourse on it. But what is more relevant is, even among those items which are assigned to the state list under list 2 of the 7th schedule, at least 5 or 6 items, once again, are made subject to the law made by the Parliament if there is a declaration by the Parliament that it is a matter of national importance. So it can keep varying. Really, the Constitution makers believed that these are matters of national importance and therefore the state should have no say in the matter. Right or wrong, their wisdom. They could have simply made, we have included 97 and 96 items in the first list, and the residuary power of 97, item 97 of the first list, is always there. And assign certain things. One example I give you, which perhaps people in Odisha will more easily understand. Laws dealing with mines and minerals and taxes on mines and minerals, that mining activity, are essentially under the list 2, entry 23 and entry 50, if I remember right, if my memory is not failing. But then both the entries are made subject to a law made by the Parliament in excess of the power under entry 54 of the first list. So what you give with your right hand, you take it off. 1957, the Mines and Minerals Development and Regulation Act was made. All major minerals, whether they are available in Odisha, Andhra Pradesh, Gujarat, Kashmir, or any other place, eventually the control is with the government. And please remember, it's a major source of revenue for any state, in any country. Most of the wars which we noticed, apart from the rhetoric, the wars are fought for resources. Whether today Russia is waging a war against Ukraine, or sometimes or America is trying to control Iran. The major idea is, they may talk about democracy, anything, whatever it is, that's not the point. The idea basically is the resources, the oil, the coal, the resources. Because they are the most important things in modern industrial world. Those days, by the time the East India Company came, all these things were not there. Agricultural land is the most. Or when Karl Marx wrote the theory, the major source of revenue is land. Therefore, the whole theory revolves around land, labor, capital, and so on and so forth. Then, if Marx were to write the theory today, I don't know who could have made slightly different theory. So, what is given is right hand is taken away with the left hand. In the distribution of legislative powers. It is one more indication that perhaps India is not a real federal country, or the constitution not a federal constitution. And to come to my own judiciary, people, all those fine gentlemen and ladies who talk about judges appointing judges happens only in India. In America, a judge in a state court is never transferred to some other state. It happens only in India. And unfortunately, or fortunately, what I don't want to add any adjective, it is a brought over from the government of India. As the British looked at the judicial system and judges on par with the ICS or IPS officers. They are equivalent or they are better, I am not going into that question. But the members of the judiciary were treated alike by the British. We borrowed that. We have a specific provision in the Indian Constitution regarding the transfer of judges. And this kind of a power can be used the right purposes or wrong purposes. And more often, in my personal view, I may be wrong, I may be corrected. More often, this power is used for wrong purposes by any government, anywhere in the world. Because independent judges are a nuisance for any government. So, you can always hold the transfer is something. Even for officer, but then for an officer, he has an opportunity of going and challenging his transfer before the court, so long as the legal system is intact. For a judge, that possibility is not there. It is shut down by the Supreme Court. You can't question it. Maximum, you can make a recommendation to the judges of India. Or if you have enough connections, you can manipulate here, there, some Supreme Court can, you can go there. The point is, this very fact that now, what was the reason? Eventually, the provision was there. Very rarely, for the first 30 years, judges were transferred. Very rare occasions. Genuinely, in the interest of the administration of justice, some transfers were made in the first 30 years. In 1980s, when this transfer policy was introduced as a policy, the then law minister, incidentally, he comes from my home state, not today my home state, earlier my home state. He made a speech, thunderous speech in the Lok Sabha. I don't know, Mr. Loknath Chaudhary was a member those days, 80s? Okay. He made a speech saying that chief justices are becoming, they're building empires of their own clan. Successful, there are courts in this country belonging to X community, Y community. So there is some truth in it, not an absolute false, some truth in it. But the remedy appeared to be worse than the disease. The second question which I would ask, however bad or unwholesome a chief justice is in promoting his own cut and kill, does the chief justice have much greater power than a chief minister? If that is the consideration for transferring, I think chief ministers also should be transferred. Wherever there is a complaint, chief ministers also should go out of the country, that particular state. I think the logic is not, that's all I'm trying to say. I'm not saying it's not possible. But this can be it can affect the independence of the judiciary to some extent. That's a different topic altogether. But point is, these are all indicators of this fact that it may not be a federal constitution, at least if we take it on the model of the American Constitution. It is a federal constitution of its own kind. Whether it's good or bad, whether it's serving us well or not, well, it's for the people of this country to decide. And how to deal with it is a different story. I think I would stop my speech here. There are two questions now I'm going to answer. One is one nation, one election. Sir, whether it's a practicable idea or not is a different question. Personally, I believe it's not a practicable idea because we know how the governments are formed and how the governments fall in this country we have seen for the last 75 years. So in which case, making the whole life of the legislative body coterminous with the life of the parliament doesn't make, even the life of parliament, okay, for the last 10 years it's all right, first 30 years it was all right, it ran for full 5 years. But there was a phase after 1989 till 2014. The governments at the Delhi level, central government, so-called central governments, they lived by the skin of their teeth. And what all circus went on, we have seen. In this background, whether this experiment would succeed, I have my doubt whether it will succeed. Now, whether legally it is tenable or not is a different matter. Legally, if the parliament decides to amend the constitution, I personally don't see any difficulty in law in that. Whether it's a wise thing or not, it's not for judges to decide. That's where I defer to the wisdom of the elected members. It's for the people and their representatives to decide whether it is a desirable thing or not. That's all I can say. Then about the Presidential reference, the second question posed by me. This is a tricky area for two reasons. As a former judge, I am bound still by some discipline. The matter is now before the Supreme Court. But as a citizen, I can always express my view. 143 or 142, relevant article is 143, I think, numbers. Authorizes the President, when the President is convinced there is an important question of fact or law, which requires the elicitation of an opinion from the Supreme Court. The text of the Constitution certainly authorizes the President to make a reference. But the question is where the field is totally unoccupied. There is no answer. Or whether the field there is a judgment and which is highly doubtful in the views of those who are trained in law. A reference can be made. Power certainly is there by the President. But the question is, when a bench of the Constitution, the Supreme Court, declares the legal position, and I can say with this much I can say as a lawyer, as a former judge, I have gone through the judgment very carefully. I don't find anything wrong with the judgment. But the questions are raised, how can they direct the President or the Governor? With anti-democratic forces, somebody described, some gentleman in a high office described anti-democratic forces. What I fail to understand is, if a bill passed by the Legislative Assembly, elected members of the people, representatives of the people pass a bill, and one nominated governor can sit on the bill for 3 years, it doesn't appear to be anti-democratic. Now, the bill may be an absolutely bad bill. It is to be examined independently. Then it was in an ideal case to refer it to the Supreme Court's opinion. In that case, not sitting over it for 3 years. That doesn't appear to be anti-democratic to them. But then when the verdict goes against them, everybody is agitated. Let us see what the Supreme Court decides. Because the reference is before them. Two judges have clearly spoken, sitting judges, saying that this can't be done. Now it is to be heard by 5 judges minimum. Whether the other 5 judges also give the same opinion or not, I can't speculate. I'm no astrologer on that. But my personal view is, the reason is simple. Once again, starting about the colonial legacy, it is exactly the colonial legacy. The king can do no wrong was a doctrine in English law. The king can never be subject to the judicial process. But that is not the case in a democratic society. Every public office holder is answerable for every discharge or non-discharge of the public function, is answerable to somebody. Primarily answerable to legislative bodies, the parliament. Unfortunately, in a democracy governed by party system, parties which have majority can simply ignore it. They don't ask the accountability. The accountability of the executive, first accountability is to the legislative body. But in the party system, that question is not raised. Then somebody else will have to look into it. When the judiciary looks into it, you question it. Well, let us see what happens. To my mind, I have no difficulty in believing that the judgment is right. Very well reasoned judgment. One more aspect, in fact, I forgot. Talking about the legislative powers, the finances, the distribution of finances, substantially most milk-yielding cows are with the Parliament and the Government of India. I was just checking up this evening before I came here. The revenue for 24 financial years for the Government of India is something like some 33 crores or something like that, both direct and indirect taxes. And the biggest state in the country, UP, its revenue is about 6 lakh crores. and Tamil Nadu is about 3.5 or 3.7, something like that. And how is it then ultimately revenues are contributed by the people of this country in different states? What is their contribution and why should the government of India be... Now, government of India is entitled certainly to get money for running some common constitutional requirements like defense, so on and so forth. But then collect the whole money and distribute it. Is it really consistent with the democratic federal structure? Another question. So these are the various indicators to my mind to believe that we are only a federal, we believe that we are living in a federal country. But in fact, I doubt it very much. Thank you.
Okay,